delighted to have as speakers Mr. Dhanuka, former Chief Justice of the Bombay High Court, and Mr. Darius, Senior Advocate, former Advocate General, and former Attorney General. This seminar is being telecasted live on our YouTube channel, and very soon, in a couple of days, we will also be circulating a link for today's seminar for all our members. May I request our President, Mr. to welcome our esteemed speakers in our midst today and begin with today's seminar.
Former Chief Justice of Bombay High Court, Shri, my friend Darius Khambhatta, former Additional Solicitor General and former Advocate General of Maharashtra, Mr. Retd is known Vice and Mr. Secretary of the Association, all members present, and those viewing it on ladies and gentlemen. A very warm welcome on this great day. Thank you all for coming. A big thank you to former Chief Justice Shri Ramesh and Shri Darius for having agreed to address this seminar. The seminar on the shortcomings of Arbitration Act and if need be, what amendments should be carried out assumes significance because Law Commission has constituted a committee to suggest changes in Arbitration Act. Bombay is a commercial city. Bombay has contributed a lot to the development of arbitration law. And Bombay Bar Association has always constructively contributed. Whenever some law is proposed, like 2 years ago, when Mediation Act was proposed, Bombay Bar Association made representation to the visiting select committee on the same. This is an opportunity for us to deliberate and suggest changes if required to the Arbitration Act. And who better than the two eminent speakers we have amongst us today? The Act has undergone 3 amendments already, last one being in 2021. And Chief Justice Dhanuka needs no introduction. He loves the subject, had an extensive practice while at the bar, and has delivered several leading judgments on the subject. He has addressed several seminars on the subject at various fora. And I'm sure by his third innings, he would be contributing much more as an arbitrator to the profession. Shri Darius, if I am not mistaken, was part of a committee which suggested one of the previous amendments to the Act. He has extensive practice in the law and has conducted innumerable international and domestic arbitrations. Sir, thank you very much again for having come today, both of you. And so without taking too much time, let us express our thank you to them by giving a big round of applause.
After reading this act, I think in the last 27 years, more than 270 times, I am struggling with the information. We have to suggest some amendments. This act, I don't know twice to come this. But every arguments of the laws and different judgments from all of India, including Supreme Court, makes us think to clarify some doubts related to the original act, as well as what the judgment chapter said. Some problems are created in the original act, and some are created by the judgments. One or two I would like to share my experience with the judgments which requires some amendment in the statute. The last judgment which is troubling all of us is in case of NL Global Mercantile versus Indian Tax Limited. As you all know, the judgment in case of Dhanuka was referred to larger bench. Our own bench, comprising of Justice Ramesh, Chief Justice, Assembly Justice Dhanuka, the full bench and interpreters section 11, 6A, SMST, and their judgment was not only section 11, 6, but also section 9. It has been overruled by Supreme Court without there being an assembly. Supreme Court was considering the case of Bombay, therefore, somebody pointed out the Supreme Court that Bombay Act has been given a judgment of section 6 and 9. And their judgment was not before it, and in one line, full bench judgment of Bombay Act was without any discussion. I am happy to say that the issue set aside by the Supreme Court was only in respect to section 11(6) and not section 9. Fortunately, section 9 still survives, but I am amazed to see that one way of one view of the Supreme Court is that if the document is insufficiently stamped or not stamped at all, arbitrator will calculate the process to you. But if implementation of the section 9 is to be considered, Supreme Court has fortunately not addressed the issue. With the view taken by Bombay Act, which still continues. But with great respect to the Supreme Court, the Retd still continues. It can be that for the purposes of approving arbitration of the section 11, the document is insufficiently stamped, then it is inadmissible evidence that not exist. But for the purposes of granting eligibility under section 9, you are not required to look into whether the document is sufficiently stamped or insufficiently stamped or not stamped at all. Because of this judgment of the Supreme Court, and to all judgments which I have made in the last 1 year, I would like to make some suggestions for kind consideration of the Bombay Bar Association in the first instance, and the Bombay Bar Association is satisfied that it requires some consideration by the government or by the committee appointed by the government, then the committee can also consider it. Now, one of the amendments I will be suggesting for the definition of arbitration agreement under section 7 is shall include an unsecured agreement or insufficiently stamped agreement or recorded in an unsecured contract or insufficiently stamped. Then, as far as section 8 is concerned, our suggestion is that as of today there is no time prescribed under section 8 for deciding the application for revenue parties to arbitration in a pending suit. Some time period also shall be prescribed under section 8 for disposing the application for revenue parties to arbitration. Another suggestion under section 8 is that if judicial authority refers the parties to arbitration under section 8, immediately by way of appeal under section 37 of the Arbitration Act shall be provided. Otherwise, the plaintiff is such that if the judicial authority wrongly refers the parties to arbitration, has to go to Supreme Court directly and approve the cases. So now, remedy of appeal shall be included under section 37. Because remedy is already provided, the judicial authority refuses to refer parties to arbitration in the application of section 8. But there is no remedy of appeal if the judicial authority refers the parties to arbitration. In section 8, again, the suggestion should be clarified that if arbitration agreement might not exist Parties say they refer to arbitration irrespective of fact that arbitration agreement or the main agreement containing arbitration is unstable or insufficient or not. As far as Section 9 is concerned, by submission, it should be verified that interim measures will be granted by the court even against a party who is not a party to arbitration agreement, but claiming through a party agreement or third party. Our legal rights has already considered this aspect of the matter. In case of Mehta, their division is considered on the legal side rule, and it interpreted as expert as the third party is going to be interpreted by asking the interim measures of the court, then notice should be given to the third party. My suggestion is that instead of relying on the legal side rules, it will be part of Section 9 itself, by way of amendment. We have more clarity. Time for disclosure of application of Section 9 by court also should be provided. Because that will be 2015 amendment. If arbitrator is afforded during the presence of Section 9 application for even prior amendment, not by afforded by the granting entity that as a party go to the arbitral trial. Therefore, some guidelines should be provided for disclosure of Section 9 application. It shall be provided that court shall have powers to grant interim measures for such period as it is good, even in case of an arbitration agreement of strength or insufficient strength, or is recorded in an agreement which is not strength or insufficient strength. This suggestion is to the safer side because as of today, because of the fact that the Supreme Court has allowed us the aspect of the interim measures in the granting of Section 9 of law. Where the document is insufficient to stand for stand before. And then the penalty formed by the Supreme Court of High Court and some states, they are going to overcome the difficulties. You should carry out some amendment in Section 9 and you will provide that document for granting interim relief. It is not necessary that the agreement is required which is not the law. Also, have powers to grant interim measures, including interim injunction or appointment execution, not arbitral law, even if claim made by the applicant towards the digital claim, or the respondent who had made complaint is rejected by the arbitral tribunal, which avoids the subject matter of petition under Section 44. This suggestion is to be stated that one of our division judgment in case of death in the act, division bench to conclude that if your claim is rejected by the arbitral tribunal, and you are in court under Section 34, you apply for relief, interim measures under Section 9. Because of the principles that are the Supreme Court case of one standard, Dhanuka, we talk about that court has no power to make an everybody correct an error within the parties. You cannot correct an error at the satisfactory court or appel the error. You leave the parties to the level of the law. Because of that judgment, that is the particular thing which is subsequently followed by other legal cases. Then if your claim is rejected under the arbitral tribunal, and your amount is subject matter of petition under Section 34, then since court will not be able to grant you relief and allowing the claim is rejected by the arbitral tribunal, court cannot grant interim relief because interim relief is paid off for the relief. So the court will not be able to make an amount of favor by allowing your claim. There is no question of granting interim relief. I personally feel that this requires some clarification because judgments are consistent one after another by amendment in Section 9. It should be clarified that whether claim is rejected or not rejected, or should have full-fledged power to grant interim relief. And give you a relationship in case of shooting or claim for specific performance, which is in respect of an immovable property. There was an injunction lying in favor of the claimant throughout in the arbitral proceedings. For some reason, his claim is rejected by the arbitrator. Under Section 34, and one will be helpless. And we can't protect the subject matter because we don't have any specific performance. If this one is relatively only for damages if it succeeds in section 34 provision or in some states under section 37 before the appellate court or before Supreme Court. This is what amendment I suggested should be made to work on this difficulty. The section 11 is under a lot of debate. After documents are there, some are notified, some are not notified. And this is the matter of debate where even one thing will be insufficient to come to some conclusion. What should be the parameters of the law. And also, procedure section 1168 was promulgated by Act 33 of 2019. The purpose of section 1168 was that all courts should be confined to the arbitration registry.
41 I was.
But unfortunately, this section is limited, but fortunately not brought in effect so far. The effect of this will be this is brought into effect. That means once you raise any prior issue before court, court will either the judgment in case of vested insurance of the law. The Supreme Court has definitely done 3 types of issues may arise before court under section 11, whether arbitration agreement exists or not, who has to decide whether merits are there in the matter or not, arbitrator will decide. In some issues which can be decided by both, for example, in case of arbitrability of claim or apparent satisfaction, those issues can be decided by both. Instead of opening the market by suggesting that 1168, this division is not notified, should not be notified. Our section 1168 should be restricted. Our court section 11 is to decide the application shall be restricted. Courts shall be allowed to arbitrate irrespective of the fact whether arbitration agreement is constituted by its resolution or not. Such issue can be decided by the arbitrator. In one of the matter recently, after Bombay court as an arbitrator, where it was very clear that all contentious issues will be raised in section 16. Otherwise, section 16 can be involved by an arbitrator applicant outside the intervention of the intervention of court. But here it was very clear. So, similar situation can be taken care of. Instead of deciding the issue whether the document is scanned or insufficient is scanned or not, that can be referred to arbitration. But more order after I read yesterday, where respondent raised the issue, the document is insufficient scanned. What should be done in this type of situation? The court should inform the document, refer it to the adjudicating authority, or also decide itself whether it is sufficiently scanned or not, binding and refer to arbitration. What is noticed in these orders that are recently passed is that when there is likely to be a counterclaim, then this issue is not raised. Because if you want to make a counterclaim, obviously, if you raise an issue that the document is insufficiently scanned, then your counterclaim also will have to you can't do that counterclaim unless document itself is first considered in the state to be state. This has become a defense or a tool to delay the outcome of arbitration. That is the purpose of arbitration. You can say clearly that there are different on interpretation of section 16. Then arbitration agreement can be similar to the agreement. Document is ultimately held void. Arbitration agreement will not come to an agreement. It will be still very exception. Unfortunately, 3 versus 2 remain lower over all the arguments of the respondents. And even section 16, what to have been taken into consideration in the right perspective. The Supreme Court unfortunately did not consider that and came to this conclusion that arbitration agreement also will come to an end, or it would not exist there is advocacy is sufficient. Another aspect of arbitration agreement which I was children for what we have considered and I hope taking some time to consider that arbitration agreement is threefold or fourfold in the sense of by recording arbitration agreement by data, communication, telegram, email, and all that. Not only that, but even the statement of claim. If you assert that it is not denied as a responsible, then also it will come out to arbitration agreement. Now, how do you stand this problem? Then I would say that as a company, the architect said, this should be required to stand. Then you will do it with the statement of claim. How is that possible? These aspects requires reconciliation and request to Bombay Bar Association to make some implementation of the application before the Supreme Court for constituting a larger case so that this issue, which is probably all over India, and the document is sufficiently stand or not, what should be done should be made in order of implementation and followed by the appeal, religion, education, Supreme Court. There will be 4 more proceedings. The whole purpose of arbitration is being frustrated with great respect because of this judgment of Supreme Court. In my view, Section 1670 incorporated, a part of Section 1670 incorporated in Section 11 of Section 7 to treat the arbitration clause of any part of the contract as an agreement independent of the other terms of the contract. In Section 11(6)(b), it shall be clarified that all the legal issues, including the issue of existence of arbitration agreement and limitation to filing arbitration application and arbitrability of claim, shall be decided only by the court and not by the institution or such party designated by court for appointment of arbitrator. Now, this 11(6)(b) is not a topic. I want to suggest someone because as a matter, outside of arbitration is and the institutions are your graded council. And they are also graded. You get your application of the section here is done. What will say go before XYZ issue good article says that judicial powers are not delegated to such institutions or the authority will be delegated to the The judicial power in what states, because now it is held by our court of Article 137 applies to the application of appointment of arbiter under Section 11(6). You simply suppose to say that all issues should be decided by the institutions who is going to appoint arbiter. Institution is not a court. But it is partly delegated to the power of the court. All those decisions which are required to be decided only by the court, which totally is executed by order, then shall be decided by the court and is not to let the institutions of the delegated authority. What shall have power to appoint an arbitrator to be considering the statement of disclosure in writing from the prospective arbitrator? I have seen the trend in the last few years. The judge here in Section 11 regulation. Both parties are very clever that offers some neutral person as an arbitrator. And thereafter, that order is followed in the direction that the prospective arbitrator should find a statement of disclosure in the Section 12(1) that we have made. The authority is again part of this one. My suggestion is that it should be part of the amendment itself. That unless the prospective arbitrator files a statement of disclosure, court shall not make the appointment, for this is a stipulated. Then after appointment, if makes a disclosure that you know the party, or he is overlooking the work. For some other disqualification, describing the civil side, we will be able to get as arbitrator. Again, we come back to the point that apply for replacement of arbitrator. To avoid all these problems, My suggestion is that at the first instance, before appointing an arbitrator, we ask for disclosure, general order for execution. Arbitrator will disclose if it is able to take this matter or not, whether it is able to complete the arbitral proceedings within the time prescribed under section 29 of the Act. This system should be corrected. I would suggest that the system suggests should be improved. Unless I can suggest that this can be a part of the appointment under section 11. 11B is can be substituted by the exercise that also required to decide the application within 3 months from the date of submission of notice of the opposing party. This suggestion I am making for this reason that the Act is 30 days. Court shall decide. Now, what happens is court has to decide what court is able to decide it. Because treating under section 11 also takes lots of time. The one said that court has committed contempt. But court has committed violation of section 11 by not deciding the application for the 11 days. So, it should be clarified in the protection of court, the protection of disadvantage to court. That person may have endeavor to decide section 11 application. Explicitly to not let out the months of 6 months. Other sufficient time is given to the court. About arbitration fees, court schedule, it is again one of the most arbitration issues. I also want to state what are the people are going to just clarify it. It shall be clarified that the rules made by the respective courts regarding fees payable to the arbitrators, including the percentage of fees payable, stage-wise shall be read in schedule 4. To the extent not inconsistent with it, certain percentage of fees shall be made payable to the before the release of fees. And what has happened is that schedule 4 does not describe any slab or at what stage how much amount has to be paid to the arbitrator. Our High Court has prescribed it. But even to that, when we drafted the rule, I also drafting of the rule, we did not realize that suppose the matter is settled, some parties they did not reject the matter on the ground of settlement. There are 5 meetings, 10 meetings, and after 10 meetings, you tell the arbitrator that now matter is settled. So arbitrator must have taken some advance from you. The next request is that now since there was no schedule of claim that is settled, you are not entitled to anything. You will refund the amount taken in advance for this. One of our arbitrators was required to do that. My suggestion is only this, that each High Court has certain arbitration rules. Those rules shall be read as part of section 11 or part of schedule 4, so that there is consistency. One more suggestion I am making is this for this system. When we have High Court rules or even official arbitrator, at that point of time they will consider very high court judgment. Where the rule taken was that claim includes not the claim. Now, as a result of that, the interpretation was that if your claim is more than 50 crores, 30 crores, counter claim is again for 50 crores. So 30 plus 50, it will be total salary, the highest sum for which you will be entitled to be entitled to 20 lakhs. In case of a sole arbitration, 20 lakhs. But because of the interpretation of this for the first case, now it is clear that claim and counter claim both are claims. And in the section 38, the claimant is entitled to ask for deposit separately to claim and counter claim. There is particular level of simultaneously referred to High Court rules. So while they are appointed to section 11, it should be clarified that in case of both, we have to separate. So 38 is very clear, otherwise also we have also articles when we have taken this view that unfortunately is a separate claim, separate fees for the individual. Now in the subsequent events, it should be clarified by our expression by adding this expression to schedule 4. The provision shall be made for Deposit of fees payable by both the parties in court, stage-wise invitation, arbitrator appointed by the court. Arbitrator shall be allowed to withdraw the law because fees and expenses out of such amount stage-wise. The provision shall be made in the Arbitration Act for making the compulsory for the child of levels on several arbitration centers within the country scope. And according to the seminar, last Khambhatta was also part of the seminar. The arbitration center is one of the unique arbitration center. Bombay High Court proposed to have its own arbitration center because of the lack of space now. The proposal is postponed for the time in some stage. Bombay Bar Association will take a representation to Bombay High Court to having a separate arbitration center. Why I have suggested deposit of fees? This is possible as a arbitration is to the court of the system. But then we have to buy out the proceedings. You know that what will pass out for a bit of schedule fees. Just ask parties to deposit the amount to court because as a part of state costs according to schedule court. Arbitrator can apply for withdrawal of the amount to court on making a simple regulation. What is happening is that the respondents sometimes are advised not to be arbitrated fees. As a result of that, there is one level where the commission to share the fees of respondent or not. When the arbitrator will look upon you, respondent is not paid, level where is still why should I pay? The option available to the arbitrator to suspend the proceedings or to terminate the proceedings. Let's say we otherwise proceedings are terminated, and what happens to the arbitration agreement? This arbitrator loses fees, second arbitrator will ask for separate fees. Again, the same approach to the respondent not to pay his fees. The claimant will always pay the presumption against the agreement. This problem normally arises on behalf of the respondents, and how respondents are advised sometimes by their advisors. It shall be provided that the replacement is prescribed in the contract lower than 4 schedule, then parties shall pay the fees prescribed in 4 schedule. What is happening is, particularly in the case of government contracts or YTC contract, their fees will be even lower than 4 schedule. Because now the government proposed to arbitration has said, as a distributions will be allowed to go arbitrator. There is protection of the element of at least equal for fees. So, by suggestion is that it should be incorporated in the Act itself that if the fees prescribed in the contract is lower than schedule 4 fees, then at least schedule 4 fees should be paid. I am not suggesting because I am not as committee applicants, they don't agree with the limit of 4 schedule law or the system. I am not going to comment on that. But at least schedule 4 fees should be protected. Schedule 4 fees can be amended from time to time after this discussion with all stakeholders, including members of the public utilities. Section 11A is provides for how central government to amend 4 schedules. While I have gone through the judgment of Supreme Court in all these cases because my suggestion is that timeline should be prescribed for amendment of 4 schedules. As central government will conformity with the issued by Supreme Court OIGC versus Circles, 4 schedule can be amended in consultation with all stakeholders. It shall be very clear that the fees prescribed in 4 schedule shall be applicable in what matters. This is another matter of debate. What is happening is that if there is an application of such figure, then court takes care of that situation. One will make it clear that whatever is the fees prescribed in the schedule 4, or maybe High Court rules, arbitrator will take that into play. But arbitrator can be appointed even in a regulation, or in the section 9, or under section 89 of CPC. In that situation, what happens? Then the arbitrator said that I am not appointed under section 11 because schedule 4 has something to do with section 11. Section 9 I am not going to charge you. And I am appointed under Section 89 not outside the without inclusion of court. I am entitled to charge into my suggestion to this. Then it should be made clear in the statute itself in what circumstances you will be entitled to charge more fees. There is a lot of arguments amongst the arbitrators also is the litigation. If the arbitrator is appointed without intervention of court, arbitrators are charging different fees. If they I go to Section 11, I will give this order to one of the lawyer as an arbitrator. If I go to outside intervention, without intervention, we will charge X Y, and I will give both of us will go to court and get him appointed under Schedule 2. So these are the regulars which I am suggesting about Section 11 should be cured at the earliest. And Section 14, if you know, if there is a dispute whether the mandate is terminated or not, you can apply under Section 14 to go to court. My suggestion is that time limit shall be provided for disposal of the litigation made by a party to the court of termination date of an arbitrator. And order passed under Section 14 shall be made applicable under Section 37 of the Arbitration Act. Then Section 16, issue of validity of arbitration agreement on the ground of insufficiency or unstable contract containing arbitration agreement can be allowed to be raised under Section 16. Time limit shall be prescribed for deciding the application under Section 16. It shall be provided that arbitrators shall pass a reasoned order on the application under Section 16 and shall communicate such reasons to the parties immediately after passing the order. What is happening is that in one line in the minutes of the proceedings, arbitrators say that I have noticed. Now you know the Dhanuka under Section 16(5). Once the arbitrator says that he has jurisdiction, does not accept your jurisdiction. He may even not have the Section 34. Don't get any appeal granted under Section 37. You have to wait till the entire proceedings are disposed of and you can give your award. So, at least it should be given reasons and also be completed immediately. So, this is my order. I have objected your plea. Resolution, which you have to advance. You can take a call whether to cure the defect or to wait till award is covered with the arbitrator. About 17, possession is made for maximum duty for considering the application for entry basis. And time shall be prescribed for disposal of the application for entry basis under 7. What is happening is that when you come to court under Section 9, you are in health, there is some urgency in the matter. You ask for some entry basis, the arbitration petition is there, then you have the ability to reply. Some basic difference is there. You can go to arbitration directly, and most probably this finance company transactions are seen. Entry application for appointment of policy is made under 70. There is no statement claim about the and unless final relief is more to the arbiter, to consider the review basis. My suggestion is that unless meetings are completed, at least before the arbiter tribunal shall not consider the application for entry basis final. Because if then what release required for entry basis on a particular basis, it cannot be found part of final relief in the statement of claim. Therefore, without release, also not admitted into relief under Section 17. Or the grant of the underrated grant aid to relief, immediately ask for the proposed statement of relief and shall consider entry basis final. About Section 19, where the power is given to the arbiter to determine the admissibility, whether as ability to weigh the evidence. This I want to make a suggestion that it should be in accordance with law, not about arbitrary things. That I think this is admissible, this is inadmissible. It should be principles of natural justice should be considered in the state of section 19. Now section 20 there is a lot of criticism of the judgments of Supreme Court about how the seat increment place of arbitration. As a student of law, I can't understand why these three different concepts. Seat and venue, which was the expression considered after the and also, I don't know by one judgment of Supreme Court, the principles which are applicable to international commercial arbitration are extended to domestic arbitration. Because of the judgment now, everywhere there is a controversy, there is everyone provides for one passing section, one passing for venue, and venue agreements are Bombay, arbitration is a seat of this will be Madras. So which court will never be judicial to pass an interim order under section 9 or under 34 or under 37. My suggestion is that it should be very simple, for this three, that there will be one simple rule, that this is the place where one will have judicial for all purposes. Section 21, my suggestion is that it should be clarified as to whether the party involving arbitration agreements are quantified the claims details in the notice involving arbitration agreement or not. Section 23, time to file claims prescribed shall be reduced. Parties shall quantify the claims in the statement of claim and counterclaim. This is also criticism that sometimes parties seek a declarative relief without any quantification. Our quantification depends upon the declarative relief. Claim for parties of dispute. One doesn't know what is claim. Tentative claims mentioned in the statement of claim. This is also for the reason that when an arbitrator is being paid fixed on schedule basis, it is impossible in this type of situation how to compute schedule for fixed when there is no computation of your claim before the arbitration. Section 23, time to file claims prescribed shall be reduced. Parties shall quantify the claims in the statement of claim and counterclaim. Because 6 months time for filing it is only after completion of outside the intervention of court, this can be suitably reduced. Provision of section 29A4, providing for reduction of use of arbitrator use of delay shall be deleted, and consequently opportunity of being heard according to the arbitration also shall be deleted. I have not seen any order so far that arbitrators fees is reduced because of delay of this part. Arbitrators accommodates advocates and advocates accommodates arbitrators. In this process, the end result should be that we should be able to make an award. Otherwise, if we should have not make them, arbitrators advocates are responsible, advocates arbitrators responsible to use his fees. And the body will follow the court that I am aware because of this people will use. This provision is rejected and is not used. This should be deleted for the 3178. It shall be provided that the arbitral tribunals shall be informed of the interest of all the period subject to the claimant making such claim in the statement of claim or in the counterclaim as the case may be. This is a matter of debate sometimes whether arbitral tribunal has if with power to hold interest was successful for all periods from the due date to the payment of arbitral service. So whether such powers can be exercised is very rare in the statement of claim. If you have made a claim at higher rate, if you have made a claim higher than the rate published in the contract, in the other side you do not arbitrate also. Without statement of claim, without containing such claim in the statement of claim, my suggestion is that it should be part of section 31(7)(a) that prayer for specific rate of interest should be made in the statement of claim itself. Section 32 it shall be very clear as to whether arbitration agreement survives. Though arbitral proceedings are terminated, the by either party or if the arbitral tribunal finds that the continuation of the proceedings as per any other reason become unnecessary or impossible. While if for some reason proceedings are terminated, whether creditors is taken up a claim, so proceedings are terminated. In that event, it will be said that they will have liberty to file statement of claim again by invoking arbitration agreement. This picture is not clear. My suggestion is that this also should be made in this other document. Section 33, there is some specific power to the arbitral tribunal making correction to the award. There also sufficient time is already provided with corrections. Additional time is provided to the arbitral tribunal. Section 34 again is a matter of debate. Short. Section 34 has a suggestion that courts shall have no power to permit parties to give physical evidence. Because of this amendment to section 34A, that from the material available in the record. Now, there are two sets of, unfortunately, Supreme Court judgments. Some judgments prior to amendment, some judgments after amendment. The rule tender is that the appropriateness for this power to allow parties to give additional evidence in section 34 states. Then it's what we done. Otherwise, the whole purpose will be defeated. Section 34 also starts giving the evidence. Party can throw the evidence. The power will have to be as a decision. First of all, before the more under section 34. Section 34A4, my suggestion is that it should be clarified whether the award will be satisfied in the ground of claims identified beyond the scope of reference, or whether the arbitral tribunal has decided to matters or claims not even made by the party. So, the word submission used in section 34, I feel should require some clarification that award will be implemented only if the claims are beyond the scope of reference or in some other situation. 34.2b and 34.2a shall be verified under such powers of court or slow. You will see the language of 34.2b. 2a gives various grounds of challenge. If party satisfies the party promises that these grounds are met out for the interpreter of 34.2a. 34.2b, what is the court can satisfy the arbitral of various grounds for the court. So whether you don't raise any grounds for the condition, if there is a potential or there is a necessity or there are other grounds for disability, 34.2b, whether the slow motor will be done. Our suggestion is that it should be verified that the principles of the grounds available in the 34A and 34B shall be read together. The party satisfies that award is relevant under the ground, then only court should be permitted to satisfy. 34.3 again, there are disputes whether limitation for filing the arbitration petition is promised or not. Some parties they refuse to get award, or they don't claim. Then there is always a dispute that the limitation is started. Or respondent does not pay arbitral disputes. Arbitral does not disputes this copy of the award, and this type of situation will happen. Because claimant was succeeded, he has not copy of the award. We can't apply for enforcement because we cannot know whether the other side of the receiver of the litigation starts for getting a signed copy of the award. It should be clarified that if the respondent refuses to accept the copy of the award, then he does not claim litigation will start. Another suggestion in this aspect is that because of this dispute, whether signed copy of the award under 31.5 is solved parties or not. Because the arbitrator says this copy of the award. So within 1 papers, declaration of war. These should furnish copy of the proof of delivery of war to both the parties, whether it is accepted by the partner or whether it is refused, whether it is unclear partner, so that other side knows that liberation is started, other side knows that it's you can accordingly take steps for execution if the award is not prescribed, and if it is not received by the other side, then we have to wait to copy of the award served on the other side. Scope of power of court under section 30.4 also should be clearly prescribed. Then it is a matter of different circumstances. 30.4 can be more because of the power of court. The application of the inducement, fraud, and corruption in the arbitration agreement, the contract, or the agreement. This amendment perhaps was necessary because of the judgment where amendment under section 26 of the Arbitration Act shall apply the prospective right or retrospective right. As a result of that, there is an agreement by the contractors who have succeeded before the agreement. But under section 34 of the Act, are specific in certain circumstances. So, because of the judgment, there was this amendment. This amendment is of no consequence of this agreement. Therefore, one hand, under section 36, where the regulation is made for stay of order, what has been granted discretionary powers. So as to verify whether the order is to stay on certain terms and conditions or whatever it is. If their power is there, then it is additional power. The power of legislation is what is satisfied with the fraud. Not in contract, not in induced, nowadays induced or related by fraud and corruption. How can these findings be given at the stage of stay? Even if the stage of the service prior to that, this closure should be deleted to avoid any consistency between 36 earlier part and second part. Then my suggestion is that order refusing to grant and granting stay to the operation of court and an application under section 36(2) shall be made applicable. That is applicable when you apply for stay under section 36. The court grants stay or refuses to grant stay. Question arises that this is not an applicable order under section 36. Whether it is an order under the Supreme Court or under 36. This is interlocutory order, and there is a appeal. Provided to section 47, arising out of order 70, under 19, under 9, and why the stay has been rejected or allowed, there is no appeal under section 37. 37 the amendment so as to include this power. Similar power shall be granted to appeal for under 37. What should have power to modify the order that is rejected by the arbitral judge and also rejected by the other single judge. Later applications shall be provided for filing and appeal under section 37 Khambhatta prescribed under section 13 of the Commercial Court Act. Supreme Court in case of government and parliament versus also because look at what should be the freedom of petition if appeal is filed under section 37 arising out of the grounds mentioned there. Or what is the freedom of litigation in case of appeal arising out of Commercial Court Act? Commercial Court Act provides for 60 days litigation. Unfortunately, under section 37 there is no freedom of litigation. Supreme Court interpreted section 34 of the Article 116, Article 117 of the Arbitration Act and took a view that if appeal is arising out of or filed under section 37, then regulation will apply. Regulation will 116 or 117 apply for appeal or appeal arising out of the donor court will apply. Whereas in case of commercial court, 2 months period prescribed under section 30 will apply. To avoid this inconsistency, my suggestion is that step of the Arbitration Act, it shall be provided that appeal can be filed within 60 days, so that both the provisions are conformity with each other. There are more suggestions as section 38 in provision of section 38, it shall be made clear that the arbitral proceedings are terminated if the non-payment of arbitrator's fees by the payment in respect of claim or by the respondent in respect of counterclaim. Arbitration agreement cannot be revoked again in respect of such claim or counterclaim till such payment is made to the arbitrator. This is of course for the benefit of arbitrators, because the party who doesn't want to pay, he is not going to pay the arbitrator has no option either to suspend the proceedings or to terminate the proceedings. Normally proceedings are terminated. Whatever work is done by the arbitrator, whatever bids are we should be paid this case. It should not be that party doesn't pay any result and after order termination of the payment of the arbitration proceedings. My suggestion is that in this ruling about this ground, then we should not be allowed to go to arbitration again unless the fees of the arbitrator is must paid. Then section 39 of the suggestion that arbitrators will enter into the main application. Under section 39 of the court, for a whatever direction I can do for that, because the government has told me that matter is settled out of the court. The file consent was to the arbitrator, and one party will doesn't pay. So that is settled by the it is about the arbitration happens without any agents or without the case of arbitration. Situation my simple suggestion is that arbitrators should be allowed to make the application of to the court for taking the direction to the parties to pay the fees of the arbitrator. Section 43A, 48, 48 is provides for appointment of arbitration council of India. Though these provisions are essential for not notified, the separation of the should be notified. Section 87, which is covered by Supreme Court in case of Hindustan Union of India, shall be restored. And the last section is about the 8th schedule. And qualification and experience of the arbitrator described as anything for some reason. I can't just get the purpose of anything, qualification of an arbitrator. Because arbitrators have to decide anything. Both parties are likely to argue issue of jurisdiction, regulation, arbitration, all of those have to be made. Even they may think of fundamental law, basic law. I'm not suggesting that we should be with some modification, yes, we want to be restored in the suggestion. The suggestion that the evidence is that properties which should be amended should be such that it should be better on only one interpretation, not more than one interpretation. Otherwise, even arguments of the evidence with one suggest to accept not only better arguments. That is the case. In any case, a particular rule, we should not make the arbitration of complicated.
Thank you, Justice Dhanuka. May I now request Mr. Khambhatta to kindly address our members, please.
Chief Justice Dhanuka, and I'm so glad to be able to address you as that. Nitin Bhai, Venki, Vishal, and all my friends. This is such an important topic actually, because as the Indian economy grows, and we all know how well our economy is doing and what it will have to do in the future, dispute resolution of commercial disputes becomes more and more important. Now, for a variety of reasons, and rightly, our courts and judges are overburdened with so much other litigation that if this sphere was also brought back into the courts, the system would not be able to cope. So therefore, arbitration fills a very important space. And it's important to keep on looking at the law of arbitration to make sure that it provides a fair, speedy, and reasonable remedy to people who have commercial disputes. I have heard with great interest Justice Dhanuka's suggestions, and so many of them are so useful. So I feel a little daunted now following. I'll try and also pick off a few that I thought of. Some suggestions are really only housekeeping or clarificatory because the Supreme Court has already decided points, and I think the Act just needs to reflect some of those. But some might provide a directional change. But before any of that, I must say that I think by and large, our Arbitration Act today is working well. I don't think there are any major problems, and I think especially after the 2015 amendments, I think arbitration has taken the right direction here. So it's important not to make too many changes and constantly tinker around with sections because that also makes for less certainty and predictability. That said, the practice in many countries, such as Singapore, for example, is to constantly review and make changes if necessary in their laws. Let's really start from earlier sections. The definition of party. Now, here, of course, we have the whole group of companies doctrine coming in, and which has caused some uncertainty in our law. Of course, the Supreme Court Constitution Bench has reserved judgment and will be deciding on that. But I think, of course, depending on what the Supreme Court says, perhaps the definition of party should be amended to now include not only a signatory party, but any other person who is contractually bound by that agreement. And it's important to say contractually bound because in my opinion, an arbitration being a contract, unless you can say that the non-signatory is contractually bound, you cannot reach out to other more far-reaching theories to draw in people who have not either expressly or impliedly consented to that contract. So some clarification there I think is necessary. In 2(1)d, arbitral tribunal now must include emergency arbitrator after the Supreme Court judgment in Amazon. But we must also remember that Amazon dealt with a Part 1 arbitration. It still doesn't solve the issue about what happens if in a foreign tribunal an interim order is passed or an emergency award is made under a foreign institutional rule or in an arbitration seated outside India. Now that is a more vexed question because are you then giving immediate recognition and enforceability of even an interim award before the final award is made and before going through the entire process of Part 2? And therefore what I would suggest is we follow by and large a time-tested route, which is that you can bring that interim or emergency award to a Section 9 court. And a Section 9 court, therefore, I would suggest adding one more subsection to 9(1), saying a Section 9 court can also pass appropriate orders for enforcement of interim orders made by tribunals or emergency arbitrators seated outside India. That will make it very clear that that's the route to follow. And of course, the Delhi High Court and our court has done some good work on this to suggest that by and large, a party should not get two bites of the cherry. So our Section 9 court will not sit in appeal, but will only adopt broad standards as to whether the emergency or interim award was necessary to protect the subject matter of the arbitration. There's one other aspect of Section 9 which I think we should be looking at. A lot of parties rush to court with a Section 9 application. And very often a court gets drawn into the dispute and holds a mini trial to decide the prima facie case and all sorts of issues. Now, there is a risk in doing that, and the Gujarat High Court in a division bench judgment in the Asala Mittal case alluded to that risk. The High Court said, and rightly, that if right at the beginning, sometimes even before a tribunal is constituted, you have the supervising court make observations, albeit prima facie, on various issues in the matter, then is there not some kind of a subconscious pressure you exert over the tribunal that they must decide the same way even finally? Of course, they are not bound to, but we all know the impact of a High Court order, even under Section 9, on a tribunal. So, initially, the law has already put in 9(3), which is that a Section 9 court will not entertain or entertain an application under 9 if the tribunal is already constituted. Now, the Supreme Court interpreted this in a matter to say, entertain means first entertain, and if it has already heard a matter, it can then pass orders. I would suggest actually that we should amend 9(3) to say, a court shall not make any order under Section 9 once the tribunal is constituted, because that's really the province of the tribunal, and this will not only reduce the burden on our courts, but will also ensure that ultimately in the arbitration the tribunal gives its own independent view and is not pressured, even subconsciously, by something the court may or may not have said. One of the safeguards I would also add to Section 9 is that a court must, before making any order under Section 9, record a prima facie satisfaction on two things. One, that an arbitration agreement exists. That's what Justice Dhanuka also, and I think that's right. And two, that the applicant is ready and willing to go to arbitration. Because I've seen matters where Section 9 applications are made, they go on for weeks and months, and still no reference to arbitration is made. And we all know the Section 11 route takes time. So you have a situation where sometimes an applicant comes to court, makes an application, gets interim relief without so much as even constituting or making attempts to constitute the tribunal. So I think that sort of party should be put on terms straight away, and the court must then record a prima facie satisfaction that the applicant is ready and willing to go to arbitration. Turning to Section 11, again I agree with Justice Dhanuka that 11(6)(a) must be formally restored to the statute book, in the sense that there is a shadow over it. It's not yet it's been repealed, but the notification has not come. But that lack of clarity must go. Although the Supreme Court in Vidya Drolia has said that notwithstanding the repeal of 11(6)(a), the law laid down in Patel Engineering still stands, overruled legislatively by the introduction of 11(6)(a) in the first place, but that is unclear. Therefore, let us reintroduce 6(a), and with one small change. The old 6(a) restricted the 11 court to only a decision on the existence of the arbitration agreement. I would say we should restrict the 11 court to a decision prima facie on the existence of the arbitration agreement. So even an 11 court will not finally decide, but if it is prima facie satisfied, it sends the matter to the tribunal after appointing arbitrators. And I think it's a very wise suggestion Justice Dhanuka has made about when it is to appoint any arbitrator, calling for advance disclosures of interest before the appointment is made, so that there are no surprises later. Now that brings me to Section 16. And 16 is really a huge advancement in our law, and it's a section which is somewhat unique to our law, because though other jurisdictions have of course recognized the principle of competence, rarely have they put it so clearly in a statute. Now to protect that, a few more safeguards. I entirely agree with Justice Dhanuka. I'm really confused and puzzled as to why the Supreme Court gave the judgment that it did on stamping of an arbitration agreement. There was no great public interest or public policy involved in that, and I should have thought a simple resort to the theory of separability, which you find in 16(1)(b), that even if the main contract is null and void, the arbitration agreement continues, would have been an easy answer to stamp. Now, we all know, of course, that stamp is on the instrument and not the transaction, but again, I don't think that causes too many problems, because an instrument is not a physical piece of paper. An instrument is a transaction recorded between the parties. Now, is it to be said that had the parties taken the precaution of having a contract on one piece of paper and the arbitration agreement on another piece of paper, you would not require stamping? But because they printed out that clause on the same piece of paper, the arbitration agreement is void? That can't be. It has to be the juridical nature of the document, that is to say that the transaction, the document comprises of a principal contract and a separate arbitration agreement. But again, therefore, that requires a quick amendment. Otherwise, it would really ride a coach and four through many arbitrations. And all sorts of confusion strike the mind. Insufficient stamping, stamp rates may be different in different states. If you have a seat in one state, a venue in another, if you have to enforce the award in another state, this is going to cause chaos. And it's unnecessary. I don't think some great public interest is served by this. It's ultimately a matter of paying stamp. So I don't think we should really destroy so many arbitrations with this approach. But there's another part to section 16 that has always interested me. As Justice Dhanuka told you all, if you raise a jurisdictional objection before a tribunal and you succeed, then the other party gets a full appeal under 37 immediately. However, if you lose, that is to say the tribunal upholds its jurisdiction, then you have to wait out the full arbitration and undergo the cost, expense and time of a trial before you can challenge that determination. Now this actually is a departure, a rare departure that our law has made from the UNCITRAL model law. In the UNCITRAL model law, there is provision for an immediate challenge if your jurisdictional objection is rejected. Now, I am not suggesting we should go that far, but I do believe that when you are allowed to challenge at the 34th stage, the jurisdictional challenge has to be a fuller challenge than the limited parameters of section 34. Because inherently, a decision as to the existence of the arbitration agreement is factual. It would require evidence, which you may have led before the tribunal. To restrict the 34 court to a position where even on the very existence of the arbitration agreement, it cannot reappreciate the evidence, I don't think would be fair, because the existence of an arbitration agreement is the very source of the power of the tribunal. And as the saying goes, a tribunal can't pull itself up with its own bootstraps by wrongly deciding that an arbitration agreement exists, and then you're told that now only if it's contrary to public policy or if there's a patent illegality can you interfere with this decision. Now, many other jurisdictions have this. In England, for example, section 67 of their act permits a full de novo adjudication on jurisdiction, including leading of evidence before the court. Again, I don't think we need go that far. I think we should actually follow the line again that Vidya Drolia has suggested, that gateway disputes, and we should restrict gateway disputes only to the question of existence, a court must have a second look at when the matter comes to court. So perhaps we can have an amendment to 16, which says, on the basis of the evidence and record produced before the tribunal, a 34 court can itself adjudicate upon and determine whether or not an arbitration agreement existed. And we must limit it to existence, which must be made very clear that this can't extend to arbitrability, which is whether a dispute falls within the scope of an arbitration agreement. That must be left to the tribunal. So we would then bring our law into alignment with most other countries where, as far as existence is concerned, a court has a second look. As far as arbitrability is concerned, a court defers to the tribunal and will only set that aside within the strict parameters of 34. I think this is necessary, otherwise sometimes it could be susceptible to misuse, to draw people into arbitrations which they have never agreed to go into in the first place. It could even be as basic as a forgery of a signature on a contract. And if one is told that the 34 court cannot reappreciate the evidence on the proof of that signature, then a person who has never signed an arbitration agreement might be dragged into a long arbitration. 29A. I must confess one thing. Yes, I was on the committee of the Law Commission which made its 2 reports dealing with proposed amendments at that stage, which ultimately resulted in the 2015 amendments. 29A was no part of either of those reports. You'll see it. It's 29A came in later at the suggestion of the government. And I must confess, when I was asked by Justice A.P. Shah, I was against it. And I said, you cannot impose an arbitrary time limit. My suggestion at that stage was, if you want to encourage institutional arbitration, you could have a time limit for ad hoc arbitrations, but say if they are managed by an institution, you must leave it to the institution. And I think that was Justice A.P. Shah's view as well. But he said, no, this is something that is being insisted upon. So I have to now confess that I was wrong. I think 29A time limits have worked. We have to recognize that. I totally disagree with 29A4, the proviso which Justice Dhanuka spoke of, which is this question of reduction of fees. I think that's really unnecessary in a statute. That must be deleted. But the rest of 29A, I think, has worked. And we have to evolve solutions that are unique to our system and things that will work in our system. And in India, most arbitrations are ad hoc. You don't have the supervision of an arbitral institution. And therefore, it's necessary to have some time frame within which arbitrations get over. But I must, of course, tell you, dispelling this common myth, that arbitral institution-run arbitration is not more expensive than ad hoc arbitration. I would actually venture a bet that it's cheaper. Yes, you don't have that big lump sum fee that you pay to the institution, but a well-run institution will make sure your arbitration is conducted efficiently, gets over within a particular time frame, and so the money you save in that is far less than the fee you pay to the institution. And some institutions even have the practice of vetting of awards. They never rewrite the award, but they check the award for obvious basic errors. And if they find any, they send it back to the tribunal with a gentle suggestion that the tribunal should relook at this finding or that finding. And I think that's an important safeguard, because very often a successful party suffers through no fault of its own because the award has made a mistake or is badly written on some aspect, and the successful party then sees the award being set aside. So there are certain safeguards that institutions can give. Now 34. I think by and large the 2015 amendments to 34 have worked. But there are 2 or 3 small areas which need some discussion and debate. I'm not sure that they necessarily need amendment, but I think the committee should look at them. The first is the intrusion of administrative law principles into arbitration. Administrative law, as you all know, is the law that you apply to the executive or administrative authorities when they pass orders or take actions or make decisions. Being functionaries of the executive and ultimately answerable to Parliament, and being under constitutional duties to act without arbitrariness and with reasonableness, the standard you would apply to them is different from the standard you would apply to a contractually appointed arbitrator to decide a dispute. There are sufficient safeguards in the law of arbitration and in the Arbitration Act to a completely arbitrary or illegal award. But to apply the standards of administrative law to arbitrations, I think we are going down the wrong path. And I speak in particular about the application of this concept of perversity to awards. A lot of us use this word and we see it in petitions all the time. Perversity is not something that you don't like in the award. The Supreme Court in Associate Builders has given a working test of perversity. So it is said, perversity means where you reach a finding without any evidence at all, or you reach it by ignoring vital evidence, or you reach it by taking into account irrelevant evidence. Now, there's a slight danger in this test. And the danger is this. I can understand a test where a finding based on no evidence at all is something that cannot be sustained. But if you ask the 34 court to decide whether certain evidence was vital or whether other relevant evidence should have been taken into account, then you are inviting the 34 court to assess the merits of the matter. And the explanation to 34(2) says a court should not go into the merits of the matter. So there is this inconsistency or contradiction. Now, the history to this was that in Western Gecko, when the Supreme Court decided to wholesale import administrative law principles, and in fact imported Wednesbury unreasonableness even into the law of arbitration, fortunately the amendments had not come in at that stage. And that is what caused a supplementary report to be made by the Law Commission expressly referencing Western Gecko and saying, no, you can't have Wednesbury unreasonableness, and therefore the explanation was suggested and accepted that a 34 court will not go into the merits. So far so good. But subsequent to the 2015 amendments, the Supreme Court has now held that perversity, which is no longer part of public policy because of that explanation in the statute, comes under patent illegality. Now, that puzzled me itself because I don't see how perversity can come under patent illegality. Patent illegality is a question of law, an error of law. Perversity is inherently something rooted in fact. But be that as it may, if it comes under patent illegality, that provision, and if we just see 2A for a moment, 34(2)A, which deals with domestic arbitrations, does not have the caveating explanation 2. That is to say, there shall not be a review on the merits of the dispute. Now, if you just bodily put explanation 2 into 2A, you're going to have a problem because perversity requires some review of the merits of the dispute. You can't come to a conclusion on perversity doing that. So, some clarification, either judge-made or statutory, has to come, where perhaps the concept of perversity can be limited. And the Supreme Court did this in a subsequent matter, in Prismium, of course dealing with the foreign award. It added 2 caveats. It said this sort of a perversity must be something that goes to the root of the matter, and because of that, the result of the award has completely changed. That's one condition. And the second would be that it must result in a miscarriage of justice. So it doesn't allow a 34 court to start saying, is this evidence relevant? Should this have been considered? Is it vital? Or why has the tribunal relied on this aspect of the evidence? We find it irrelevant to the merits. Those exercises must be cut out of 34. And perhaps some explanation limiting perversity to cases where there's no evidence at all to support a finding, I think, are in order. By and large, our courts have resisted this temptation, especially Bombay and Delhi, the judgments are very clear. But I fear other courts might not be able to resist this temptation and might use perversity to go into all sorts of matters which really are forbidden under 34. And I only refer you to a great passage of Justice Nageshwar Rao in Delhi Metro, where he says that what happens is that sometimes courts tend to dissect an award and re-envisage it, and then use these mantras of perversity to justify what they're doing. So that's an area which I think needs some control. The second thing I've always thought of under 34, again, this may add a little challenge to the process, but why can't we have an amendment to 34 on the lines of section 100 of the CPC? As you know, under section 100 of the CPC, a second appeal on a substantial question of law requires the court to formulate that question of law. Then parties will address on that question of law, and they can also address on the fact that this question of law actually doesn't arise. And section 100 also has the safeguard that if the court thereafter going into the matter finds that another question arises, it can always frame and formulate that question as well. Now, what if we adopt this approach to the admission stage of a 34? Instead of having a stage, and we all do this, if I appear for a respondent in 34, first thing I'll tell the court is I want to put in a reply. So then a reply comes in, a rejoinder comes in, then after a hearing of sometimes of some magnitude, the court says this will have to be finally considered, so we go to the next stage and the whole thing is re-argued again. Instead of that, what if you at the admission stage of a 34 without the filing of a reply? The court only applies its mind to whether on a demurrer, the 34 petition makes out a case under 34.2 or 2A. And it's not enough to say the petition raises a question of in conflict with public policy of India. Court should formulate, as it would under section 100, that by reason of this finding found in this paragraph, this is in conflict with the public policy of India, is a question. Similarly, patent illegality, because this forces the court to focus also and formulate the question and then let replies be filed. Now I know critics will say, oh, but then you're allowing someone to go and appeal from that. But so be it, because we assume the appellate court will be disciplined enough to say this is only formulation of a question. You can always argue against it at the final hearing. Because if that exercise is not carried out, more or less every 34 petition ends up being an argument going into the merits. I do it. I am the first to say that. You try and satisfy the court of the justice of the award and the evidence of the matter, and you go headlong into that, which is not the purpose of 34. So some focusing of 34 might be in order. The third aspect which Justice Dhanuka referred to is modification of the award. Now there's a very strong argument for giving this power to a court, no doubt about that, because there are awards I can think of where one has succeeded 90% in the matter. On one small issue, the whole matter you have lost because of that one issue, and that finding is patently erroneous in law. If you succeed in a 34 in getting that finding set aside, it doesn't mean that you get what you claimed in the award. You have to then go all the way back and restart the whole matter from scratch, which is really completely unfair. On the other hand, the other point of view is, if a power of modification is given, that may open the floodgates for courts to start interfering with awards and applying their own mind to all sorts of matters. So, on balance, I would be against giving such a power to a court. Yes, in many cases that would visit an unfairness, but in the larger perspective, you have less interference in awards. I would probably only suggest a power to a 34 court in certain cases like this, where it feels an injustice has been done, to immediately either reconstitute the old tribunal or constitute a fresh tribunal and make a reference back to that tribunal, limiting it to that question. So not reopening the whole arbitration again, where fresh evidence is led, fresh arguments are led, limiting it only to that error of law which it is set aside, or the patent illegality, saying the rest of the first award stands, we sever this portion, and this refers back, can go back alone. That would be fair, because you'd get an immediate redecision, and where you have succeeded on evidence, etc., there would not be a setting aside of that. So perhaps some evolution of the law there. There are 2 or 3 other matters which our law needs to incorporate. One is third-party funding, which is very common in international arbitration, and it's very important. I know we've all grown up in law college hearing these words maintenance and champati as if there's something bad. Under English law, they're treated as something bad. The old English law is no one can maintain a litigation by financing it, etc. But actually, experience has found that maintenance, financial maintenance or funding of a litigation is a good thing. Why is it a good thing? It's a good thing because if you have an impecunious litigant who has a good cause, but he cannot afford to fight it, that good cause goes by the wayside. Secondly, if someone funds, say, an arbitration, that person will be very careful. It will vet, it will filter out, it will analyze the cause. It will only fund good causes, it won't fund bad ones. So there's an automatic filtration process at that stage. And lastly, the funder, I can tell you, is very, very particular about the performance of the lawyers, because there's hard-earned money put into a cause, so that itself improves the process. Now, contrary to what many of us imagine, third-party funding is not forbidden under Indian law at all. From Ram Kumar's judgment in 1872 of the Privy Council, third party funding is completely permissible. The only exception is it should not be something to fund a vexatious litigation or to make an extortionate profit, and it can't be done by the lawyers concerned, because then they're really funding a litigation for themselves. But with these exceptions, third party funding, and recently the Delhi High Court has commented on third party funding in a judgment, can be incorporated into our system to actually regenerate a whole number of matters which are falling by the wayside because the party cannot afford to actually go into arbitration and fight. But what third party funding needs is some regulation. Some clear disclosures are to be made, transparency, some conditions. That requires a statutory matrix, and I'm not sure that should come into the Arbitration Act, but there is need for some regulation there. One other aspect I must point out, again this arises out of two judgments of the Delhi High Court on a totally different topic. You all must have heard of this expression, bilateral investment treaty arbitration. And for those who haven't, basically it's only this, that when large foreign investments are made into a country, the investor wants protection for that investment. He doesn't want to be left completely to the mercy of a litigation between him and the person he's contracting with. So governments, to encourage such foreign investment, started entering into treaties. They are government to government treaties, but they offer the investors of a particular country the benefit of an arbitration against not the individual who they have a contractual dispute with, but against the government of that country. So an individual sues a government in arbitration and gets his award on their various well-settled grounds. Now this is again a very controversial area because some of these awards we feel have been unfairly made against India, etc., etc. But the fact is that this is a means by which you can attract investment, by giving a remedy. Now, internationally, there is something known as ICSID, which is an international convention, which gives automatic enforceability to investment treaty awards. So it's rather like our section 44A of the CPC. You just come with that award and a court will enforce it. We don't have that because India is not a signatory to ICSID, which is a 1965 convention. In India, the award has to be enforced like any other foreign award if it is made abroad. And usually these are seated abroad. Now recently the Delhi High Court in two decisions held that an international treaty arbitration award is not commercial for the purpose of section 44 of the New York Convention and our Act. As a result, the investor is left with no remedy effectively. He can't automatically enforce under ICSID, and if it's not a Part 2 enforceable award, he has no remedy under our Act, in which case he has to file a suit to enforce that, which is meaningless. Now, if the government wants to give that remedy, and even in the model BIT, which is the renewed model of 2015, which makes it far more balanced than the earlier model of 2003, provides an arbitration. If that's a meaningful clause, then you have to give that remedy of enforcement, and therefore perhaps a clarification under section 44 that investment treaty arbitrations will constitute a commercial dispute or matter is necessary. And I don't see that shouldn't be a problem, because under our Commercial Courts Act, if you read that long definition, there's an explanation that says merely because the dispute is with the government or a sovereign authority doesn't mean it ceases to be commercial, which is the basis on which the Delhi High Court has gone to say it's not commercial. So I think that's important if we really want to continue attracting investment and give investors a fair playing field. There are many other small things, but I think Justice Dhanuka has covered many of the major points, so I don't want to get into smaller points. One broad comment, the Arbitration Council of India, if you read its functions, some of them may be broad enough for it to start functioning as some kind of a quasi-regulator. Now that's not a good thing. Arbitration ultimately is a matter of contract. And as long as the rules of the game set out in the Arbitration Act and well-settled law are followed, you can't have a regulators, including accreditation of institutions, accreditation or grading of arbitrators. I don't think this is a good thing. I don't think it subserves any public purpose. I would say that in fact, what the Arbitration Council should be doing or should do, but it's not yet come into force, is something quite different. And that brings me to the end of what I want to tell you all today. Slightly off topic, but I want to tell you all this. It is the manner in which we practice arbitration. I must tell you that I've participated in arbitrations in India. In fact, probably my very first arbitration was junior to Mr. Devitri in a matter against RCF years ago. It's either that one or a matter against ONGC led by Mr. Saleh Doctor. Those two were my earliest arbitrations. I've also participated in international arbitration. I continue to do so. Now, I have seen that Indian lawyers, when we participate in international arbitrations, are really second to none. They have the expertise, the competence, and the talent to hold their own. But where we do fall behind is in different ways. Internationally now, the practices have got far developed. For example, what is absolutely basic, you don't even ask whether you have it there, is real-time transcription. Every single arbitration has it, which is what? That every word that is uttered in the arbitration, whether by the lawyers or by the tribunal, is automatically and immediately transcribed in real time. There are two stenos who have special 8-key or 10-key typewriters, and their speed is remarkable. As you're speaking, you can see on the screen what you're saying. And this goes on the whole day, including for taking of evidence. Now, the advantage of that is that there's a black and white record of every word that is said, and for a 34 court, that is invaluable. There are no disputes on this happened or that happened, it's all there. It's also invaluable during the arbitration because no counsel, and sometimes we are wont to do that, makes an argument in one direction in the morning and in a different direction in the afternoon. If he wants to do that, he has to admit that I'm sorry, I went that way, I was mistaken, now I want to go another way. But he cannot feign ignorance and say, no, what I meant is exactly the same when he's arguing the opposite. It's there in black and white. The evidence goes much faster. Everything is question, answer, no separate recording. Now, one of the big criticisms we have is, oh, but it's very expensive. And yes, it is expensive because today the technology doesn't exist in India. Often you have to import these people from Dubai or Singapore, and you pay a lakh and a half a day for that. But when you see the cost of big complex arbitrations which are held in India, the stakes that are involved, the lawyers' fees that are involved, the saving of time, because this reduces the time by at least 50%, if not more. The saving you'll make on the whole will be much more than if you didn't have this. So, I know the Delhi Center, which Justice Dhanuka and I saw, has introduced this. And I think this is one area where the Arbitration Council must start introducing it. The other area where I feel sometimes our practices are lagging behind is this myth that arbitration is completely ad hoc and discretionary and everything should be left to the tribunal without any clarity on what's going to happen. That's not how it works. Most international arbitrations start with the most detailed, what they call procedural order number 1. It runs into 4 or 5 tightly typed pages. It tells the parties the full roadmap for the future. What is the procedure to be followed? What are the rules to be followed? It may incorporate, for example, the IBA guidelines for taking of evidence, all that. So right from the beginning, you know the rules. Of course, everything is subject to the discretion of the tribunal. But then you can plan your entire strategy and your entire participation based on some certainty and not based just on an ad hoc decision at that point of time by the tribunal. Very important. Of course, there are other methods that we have to now imbibe of detailed written submissions, no ambushing, etc. But that's for another day and another talk. I think if the Arbitration Council starts inculcating these practices, and let me tell you, there are arbitrations seated in India which have already started this. I myself have participated in some, strict time limits, etc. I think there is no limit to what we Indian lawyers can do in arbitration and international arbitration. And I'll leave you only with those very wise words of Charles Darwin, who in his theory of evolution had said, if you remember, that it is not the strongest of the species, nor even the most intelligent of the species that survive. It is the most adaptable. The species that adapts to its environment is the one that survives. And I think we are now going into a new environment. We have to adapt to it. A few amendments to the Arbitration Act, yes, but we also, as lawyers now, have to evolve and adapt to international practices and maybe modify them to suit our environment, but move in that direction. Thank you.
I would like to sincerely thank Chief Justice Dhanuka and Mr. Khambhatta for taking time out from their busy schedule and for being here with us today. They have both pinpointed the myriad issues that arise under the Arbitration and Conciliation Act, and we have all benefited from their insight and incisive analysis. May I request our Vice President, Mr. Venkatesh Dhond, to present a small token of our gratitude to Justice Dhanuka. May I request a standing committee member, Mr. Farhan Dubash, to present a small token of our gratitude to Mr. Khambhatta. I would like to thank all of our participants today who are present here and who have seen this online for participating in today's seminar. Thank you so much. Please join us for tea and snacks. Thank you. Given what is said, if we have time, if we have any questions and comments, please feel free to ask one by one. I mean, if you can raise your hands and we can take it from there. Yes.
Section 9. Justice Dhanuka was sitting in a division bench in the Valentine Maritime case, where you held that the provisions of Order 38 Rule 5 are not strictly applicable when it comes to deciding a case under Section 9. This was affirmed by the Supreme Court. Thereafter, the Supreme Court came up with another judgment passed by Justice M.R. Shah, which was diametrically opposite to the judgment passed by the Supreme Court hardly 2 or 3 weeks later. Then both these judgments came up for consideration before Justice Dangre, and she came up with a middle path. Don't you think it is essential for Section 9 to clarify what are going to be the parameters for passing an interim order, whether 38 Rule 5 should apply, not apply? That's the question I have, because this is going to cause a lot of problems in other courts as well, because Bombay High Court judgment obviously is not going to be binding on other courts. And again, this matter will have to be taken to the Supreme Court for clarity. So that's the question I have for you.
See, it is clear that judgments are not to be read as statute. So that is why some of the amendments what I have suggested today is that whatever lacunas are created because of judgments should be made clear in the statute, so that capable of only one interpretation, one way or the other. I fully agree with you, judgments are inconsistent and it becomes very difficult for the single judge or the judges in the lower courts to follow one or the other judgment. There is no choice. And the law of precedent of course applies. But if law is very clear, statute is very clear, then there is no question of any other interpretation. There should be one and plain simple interpretation.
I hope I'm not monopolizing, but this is the context of Section 17. The arbitral tribunal has the powers to pass interim orders. Now, Section 36 in terms says that an award passed by an arbitral tribunal is deemed to be a decree of the court. But there is no provision relating to what happens to an order passed by the arbitral tribunal under Section 17. Now, if a tribunal order, for example, injuncting a party from doing X, Y, or Z, or passes an order which has the effect of a third party not parting with funds, how is that going to be implemented? Because ultimately, many parties may treat that order to be rather not exactly like a decree of a court. How would that have to be dealt with? Don't you think there should be a provision for that as well? Section 36. No. No, but how would it be implemented if parties are going to now disobey that order or not comply with it? There needs to be some clarity on that. Yes, but that's the problem. Again, we get into a situation where you have to then start getting into an implementation. If there's a provision in the Act to deal with a situation where parties are disobeying the order, especially third parties. Say if you pass an order against a bank, like a garnishee action, then how do you implement those orders? If there is some clarity in the Act to that effect, that's the question I have.
If you remember, earlier orders passed under Section 17, for enforcement of that order, we were required to file petition under Section 9. And then 9 order will be enforceable. Now to cure that problem, under 17.2 this amendment is inserted so that you can invoke the provisions of CPC. In CPC, there are very vast provisions for enforcement of order or for decree. So we'll have to invoke that.
I just wanted to make a couple of points. I agree that the act is. If you interrupt, it will be a long speech. I agree that the act is good, and if you see the UNCITRAL, virtually the language is similar. Just to point out why 13 and 16 don't have the appeal provision like some other countries and under the UNCITRAL, the answer was simple, that to avoid knocking at the doors and getting the arbitration stalled. Now that comes to the root of the problem, that every time in an arbitration, if an opportunity is given, the courts are burdened, that's a fact. Every time an opportunity is given to go to court, is going to delay the proceeding in a long, long time, whether you go under 37 or you go under 34, and that causes a problem. Can we not suggest some mechanism, an alternative kind of forum or special commercial courts to deal with arbitration itself to expedite this entire process? Because as they say now, okay, even if you get an award, is the beginning of your problems to get it enforced, to get it finally. So can we not, PBA, make a recommendation subject to what our people say?
Only suggestion I can give is that some good lawyers from original side should accept justice. Unfortunately, we are not able to convince. In my last speech also I said, we can only try to persuade, we can't force anybody to accept justice. And another thing is that you can always make a representation to the Honorable Chief Justice to assign more and more judges for arbitration. And whomsoever is given assignment, he should be given exclusive work for arbitration, not other subjects. That is making more difficult. Brother Justice.
There's one instrument within the Act which might do what you want, which is 31 capital A, costs. Heavy costs should be imposed if there are frivolous applications filed, even under 34.
So I just want to ask Justice Dhanuka, you've been talking about this stamp problem. It's a serious problem because, many arbitrations are frustrated or delayed because of that. Wouldn't a simple solution be, forget the Arbitration Act, why can't you introduce an amendment to the Stamp Act saying that any arbitration agreement, whether
incorporated in a larger contract or whether independent will not require stamping. Wouldn't that be the simplest solution to the problem?
As far as Maharashtra is concerned, there is no separate stamp duty payable on arbitration agreement. This is only because of the interpretation of Supreme Court that even if it is forming part of the main contract or independently, the argument of section 16 is missed unfortunately by Supreme Court. With great respect.
Every state will have to have it, no?
What we can do is, there are a couple of participants who want to ask questions. So we'll take 2 questions and then get the mic for our speakers.
Yes. So my question is, can the claimant invoke fresh arbitration when Section 34 petition has set aside the award and there's 37 appeal pending in court, which we know it takes a lot of years for 37 appeal to be heard. So whether fresh arbitration should be invoked, and is it all right, because 2 parallel proceedings is not something which is in the interest of either party.
Anyone else? I think there was a question there. Yeah.
Good afternoon. My question is the context of Section 34. Section 34 has been narrowed down over the years to the extent that even incorrect application of law cannot be interfered. Now, my question is, can an award be kept at such a higher pedestal as opposed to an order of the court also? Like, there are broader grounds to challenge an order as opposed to a Section 34. Justice Dhanuka did mention that it will amount to a first appeal. But my question is, like, 34 is so narrow as opposed to challenging an order. So any thoughts by either of the speakers?
See, there are judgments after judgments, and Supreme Court judgments gives you both the parameters when award can be set aside and when award should not be set aside. So, on the ground of perversity, patent illegality, there are judgments after judgments. Even in 2023, recently, a Supreme Court judgment has come when the award can be set aside. The last important judgment was in case of Sanjong, where in one paragraph Supreme Court said that even if there is the vital documents are not considered, award can be set aside under Section 34. But in the same judgment there are other parameters also, so you have to see. And there should not be any unnecessary interference. I agree with my brother Mr. Khambhatta that otherwise the whole purpose of arbitration would be frustrated. It should be a gross case. And all these grounds of Section 34 are interpreted by courts in different way, which will be apt for your matter, that you will have to read the judgment and apply it.
There is a good reason why there's a difference in standard. Because when someone goes to court, there's no choice. Anyone can go to court, file a suit, and you have to appear, and a decision is rendered, therefore you have a full appeal. But arbitration is a matter of contract. It's the party's autonomy to decide to go to arbitration or not. So they choose a remedy where you have this very limited challenge. It's a matter of choice. That's a very vexed question, because if you have succeeded in the 34, award is set aside on some ground. Now, a 37 appeal is pending from that. In the meantime, there is no, strictly speaking, there is no bar to your making a fresh claim. But what will happen if in the 37 appeal, the 34 order is reversed and the old award is restored? Therefore, you really can't have a situation of parallel remedies like that. The appellant can then also refer to arbitration. That would lead to a lot of complication.
This concludes our question and answer session. Thank you for joining us. Please join us for tea and snacks. Thank you.